This video documents the sentencing of Jeffrey Thomas Pennington in Gila County, following his conviction by a jury for sexual conduct with a minor, classified as a dangerous crime against a child. During the proceedings, the prosecutor strongly argued that there were no mitigating factors, emphasizing the defendant's complete lack of remorse and his continued denial of responsibility despite overwhelming evidence of guilt. She described the severe and long-lasting emotional harm suffered by the victim, revealing that the 12-year-old had even contemplated suicide due to the abuse she endured when she was only 7 years old. The prosecutor also disclosed a disturbing plan by the defendant to send a manipulative letter to the victim through his family, attempting to continue psychological harm even after incarceration, and urged the judge to impose the maximum possible sentence. Mr. Pennington chose not to speak before the court, with his attorney stating that their focus would be on an appeal. Although the court acknowledged certain mitigating factors, including family support and the defendant's physical health, it found multiple aggravating factors. These included the severe harm to the victim, the very young age of the victims, under 12, and the defendant's serious abuse of a position of trust as a childcare provider. As a result, probation was not legally available, and the court imposed a life sentence. Mr. Pennington was credited with 443 days already served but will not be eligible for release for at least 35 years.
Next matter is State v. Pennington, CR 2024-483. I'll note that Mr. Pennington is present in custody in person. Mr. Feldman, his attorney, is here. Ms. Evans from the County Attorney's Office is present. Before we went on the record, Ms. Evans indicated that the victims or victims' representative were provided with Zoom links. We have not seen them. If they join us, we'll put that on the record. Mr. Feldman, two quick things before we begin. First, your client's parents are here, correct? Yes. Okay, I'll note Mr. Pennington's parents are present. And then Mr. Feldman, I see there's a motion to withdraw. You anticipate that I address that following sentencing?
Secondary case.
Okay, and that's in Division 1, so that case is no longer active?
Correct.
Okay.
Then we filed a notice of appeal.
I'll note for the record that the court has reviewed the pre-sentence report that's dated December 30th by Officer Smith. Mr. Pennington, can you please tell me your full true name, sir?
Sure, Jeffrey Thomas Pennington.
And is he picking up, Madam Clerk? Do we need to move the microphone? What's your date of birth, sir?
70.
Okay, thank you. Based upon a jury finding, it is the judgment of the courts that you're guilty of count 1, sexual conduct with a minor, a dangerous crime against a child, the victim being under the age of 12, committed between January 1st of 2018 and January 1st of 2020. A Class 2, non-dangerous, non-repetitive felony, a dangerous crime against a child. Ms. Evans, would the state like to be heard further beyond what's in your recommendation?
Yes, Your Honor.
Okay, please.
The state wants to point out that there are basically no mitigating factors in this case. Certainly no statutory mitigating factors, not a single one, which leaves him with the catch-all mitigating factor, which there also isn't any. First, there is no remorse. Despite a guilty verdict and being confronted by the overwhelming evidence of his guilt, he still has never accepted any responsibility for these crimes, instead choosing to adamantly declare that he is somehow innocent. The defendant has never expressed any remorse towards the victim. He has never once shown an ounce of empathy or sympathy for the harm that he caused her. He doesn't care. The only care he has ever expressed was for himself. The only things that he has done in this case was declare that he was uncomfortable in the jail, complain about his treatment for his cancer, discuss how he was scratching and making himself bleed. The only person he has ever cared about was himself. And I am positive he will claim that his cancer is a mitigating factor in this case. That this errant coating in his cells that has made them multiply out of control somehow should make his sentence lesser. While Arizona law does not force you to find some sort of causal connection between mitigating factors and his sentence, it does allow you to assign weight if there is no causal connection. So if you somehow find some pity in your heart for his condition, I ask that you give that minimal weight, considering that has no causal connection with his crime. No, Judge, this man is a cancer to the victims. A cancer that continues to eat at her and will continue to eat at her for the foreseeable future. The victim in this case, the one who remembered what he did to her, is still bleeding. The mental anguish he has inflicted upon her is a wound so deep it has barely begun to heal. That brave teenage girl testified and told you that she was suicidal. A 12-year-old girl wanted to die because of what he did to her when she was 7. Despite all that pain and all that suffering that she continues to go through to this day, she still testified, refusing to suffer in silence any longer. And it was one of the bravest things I have ever witnessed, because up until she actually testified, we were unsure if this would be the right thing to do, if she would be able mentally to come up here and do this, or if we were doing more harm to her than good. But she still managed to do it. And the worst part? The defendant wasn't even done. He wasn't done hurting her. He had a plan to haunt her from beyond the grave. Using his own family. He had a letter in his computer that he planned to have his family deliver to the victim. A thinly concealed bomb to remind her of what he did to her. He would have made his own family unwilling participants in his quest to thoroughly ruin a little girl. And they would have had no idea. Fortunately, he was stopped before he could do that to her or his family. Not that he cares about his family. There was some evidence he was doing this to his own niece. But he doesn't care about that because he has the exact opposite of remorse. He fully believes that most people would commit crimes if they didn't get caught. And that's exactly what he tried to do. He tried to get away with it. He tried not to get caught. Because he doesn't understand the very basics of morality. He doesn't understand that something can be wrong and can have consequences for others, even if you don't have somebody else telling you that it's wrong and forcing you to act in compliance with very basic human decency. There is no empathy in him. There is no sympathy in him. And unfortunately, Judge, you can't fix that. You can't rehabilitate that. And no matter what you do, you're not going to give that little girl back her sense of safety. The only thing that you can do is put him in a position where he can never hurt anyone else again. The defendant can't even claim that he had a rough upbringing or there was something in his childhood that caused him to do this. No, by all accounts, he had a great childhood, a stable family, no adverse childhood events to think of. His family did a wonderful job. And his parents are here, and they were here during the trial. And I'm sure they're sitting back there wondering, what did we do wrong? Did we cause this? And the truth is, it's not their fault. But they too are victims because all they can do is sit here and listen to what he's done and bear witness. Because I'm sure they don't condone what he's done, but he's their son. And no matter what, they love him. And finally, there's the other victim in this case, the victim's mother. The mother who entrusted her child to a man that she found at church, a man of God, a man that put himself in a position so that he could do things to her children. And she's sitting there feeling guilty and torn, wondering how she could have missed it. Wondering what she could do more to help her children. This isn't her fault either. She did her best with the options that she had, despite what the victims did, but despite what the defendant did to the victims. The only correct sentence here, Judge, is the absolute maximum term that can be delivered to him. That's all.
Thank you. Okay. Mr. Feldman, I'll hear from you and/or your client.
Thank you, Your Honor. My client does not wish to address the court. So with that, Your Honor, we would simply ask the court to follow the statutory requirements under the law, and we'll focus on the appeal.
Okay, thank you. The court's going to make the following aggravator and mitigator findings. I'll find two mitigators, which is the defendant does have family support, has been mentioned. He's been at all of our the family's been at most, if not all, the hearings. I'll also note his physical health as a mitigator. On the aggravator side, the court will find that the jury found that there was victim harm to the victim KD. Additionally, the jury found that both victims were under the age of 12. Beyond that, the court finds additional aggravators of multiple victims in this matter. The court also finds the aggravator that the defendant was in a position of trust, i.e. providing child care for these victims. The court finds that probation is not appropriate and statutorily not available. Considering the aggravators and mitigators that the court has found, the statutory requirement is life, so it is the judgment and sentence of the court that the defendant shall be imprisoned for life. He will have 443 days credit as of today's date. I'll note that he is not eligible for release until he has served at least 35 years. And that sentence will date from today's date. I'll order that restitution remain open for 90 days.